first thing that you may notice is I have less hair than I had when that photo was taken. That is the result of lockdown, haircuts getting shorter and shorter and shorter. So what I'm going to do this afternoon is I'm going to cover some of the cases that have, I think, are important from the last roughly 12 months or so in relation to inquests. I am not covering every single case. There's a little list at the end of some of the ones I've not touched on. The reason is because it was getting far too long, so I've just chosen to focus on those that I think are of significance, or at least are interesting. So I'm going to talk a little bit about the regulations very briefly. ECHR, which is a case about privilege in expert reports. Maguire, obviously. Smith, which is about conclusions in Article 2 cases. Fullick on costs, and a little bit about the more recent Chief Coroner's guidance on COVID-19. So the notification regulations, it's a little anomaly, but there hasn't until 2019 actually been any obligation on a doctor to notify coroners of deaths. It was always done as a matter of course, but now it is actually regulated by the Notification of Death Regulations 2019. Don't need to spend a huge amount of time on it, because very simply, if a doctor is aware of a death and they suspect any of those matters, essentially the same reasons that a coroner has to start an investigation, then they are now obliged to notify the coroner, and that also includes if there's no one available to sign the medical certificate of cause of death. Almost immediately these came into force. They have been amended by the Coronavirus Act, so for the moment the MCCD period has been extended to 28 days, and also there's some changes in relation to who can sign the certificate. It need not be someone who's actually seen the patient, the deceased, in their last illness. Sorry, I'm just admitting people who've just joined us. So that's the notification regulations. The first significant case, and I'm trying to run through things in sort of a logical order, so starting at the very beginning of the inquest process here, is a case called ECHR and Mitchell, and it's a Northern Ireland Court of Appeal decision from a judicial review decision of a coroner. And it is a case in which the two deceased died by hanging at an army barracks. Their mothers had obtained psychiatric reports which looked at the systemic and structural issues in the military in these barracks. Somewhat surprisingly and unusually, the coroner ordered the families to disclose those reports to him or her. Unsurprisingly, they applied to judicially review that decision, and interestingly, the MOD agreed that those reports were privileged, and that would have been my assumption too. The principal basis of the application was these sections 17A and B of the Coroners Act Northern Ireland. The important point to note is that that's almost exactly the same. In fact, it is exactly the same as the provisions in England, and what they say is Section 17A, there is a power to require evidence, exactly as the power there is in Schedule 5 of the CJA. Section 17B, most important bit, is this first bit, may not be required to produce evidence or document if he would not be required to do so in civil proceedings in a court in Northern Ireland. Obviously in the CJA it says in England and Wales. Now, my understanding, and I think those of most of us doing inquest, was that the purpose of Section 2A was to import the principles of, among other things, privilege. But the Court of Appeal of Northern Ireland disagreed, and they said that, although they noted that that was the principal argument, that privilege was imported by that section, they actually said that the anterior question, which is a slightly odd phrase, but I think it means that the more important question, or the wider question, is whether coronial proceedings give rise to litigation privilege. They went through a very interesting discussion, which I'm not going to go through here, of the authorities that related to privilege, most significantly Three Rivers District Council, they concluded that fundamentally inquests are inquisitorial. The clues in the name, we know that. And they said that therefore litigation privilege does not apply because it only applies to adversarial proceedings. So it seems to me that leaves a question, which is, well, what about section 17b(2)(a), which says couldn't be required to disclose if you wouldn't be required to do so in civil proceedings? Because that seems to me to say, yes, all right, privilege doesn't apply, but by virtue of this section, we're going to import those principles but on a statutory basis rather than a common law basis. Well, what the court said was, although litigation privilege doesn't apply, they go on to say, however, there is this other bit, section 17a(4) and 5, which again is identical to Coroners and Justice Act, paragraph 1, 4 and 5 in the schedule, where there has been a notice issued by a coroner, the person may make a claim that he is unable to comply with that notice or that it is not reasonable to comply. And in considering subsection B, the coroner has to consider the public interest. So this is really a get out clause. If you're given a notice to disclose something and you don't want to, then you can apply to the coroner essentially to set aside that notice. And the Northern Ireland Court of Appeal looked at that section and how it would have applied in this case. And they essentially hinted to the appellants that they ought to consider making an application. And then they also gave an indication, quite a strong indication, as to what the result of that application might be. And they said the coroner, in balancing the public interest in ordering disclosure with the coroner's interest in seeing the report, that the reports in this case were of modest importance at most. They noted that in almost all cases, any expert report would have been for the dominant purpose of the civil claim, and therefore, in the vast majority of cases, there would have been no power to require the production of it because it would have been privileged. Even if that didn't apply, the interest of the family in preparing the case, which is obviously the purpose of privilege, would normally outweigh the coroner's interest in receiving it. And when considering the public interest, compulsory disclosure of these reports as a matter of course would be likely to discourage these types of investigation. So the question that still remains is, what's the purpose of the wording of that subsection? I.e., you can't be required to disclose something if you could not be required to disclose it in civil proceedings. Respectfully, I disagree with the Court of Appeal, and my view is that that clearly is intended to import something which otherwise would not exist in inquest proceedings. But in any event, they made very clear that in most cases it wouldn't be disclosable because it would be privileged. The reason for that, of course, being that it would be for the purpose of litigation. So the first key point is if we're obtaining a report prior to an inquest and we don't want that report to be disclosable, then we need to make sure that the purpose of that report is clear. And if it is for litigation, which often it will be, then that needs to be made clear on the instruction. That's a relatively simple process, and that will prevent it becoming disclosable. If all else fails, then there is the provision that I referred to a minute ago, Schedule 5, 1, 4 and 5. And the Court of Appeal, Northern Ireland Court of Appeal here, were quite clear in their indication that in most cases, the public interest would be against ordering disclosure. So hopefully this shouldn't present any major difficulties. And it's certainly not an issue I've ever come across, a coroner asking to see a party's own report. But hopefully, as I say, that won't be a major issue in future. So the next issue, trying to think about things chronologically, is engagement of Article 2. And obviously the most significant case we have in this area has been Maguire, which looked at the application or engagement of Article 2 in relation to those who are deprived of their liberty under the safeguards in the Schedule 1 to the Mental Capacity Act. Went to the Court of Appeal, and I thought before we get to look at Maguire, I would just very briefly do a refresher on the provisions of Article 2. And I've stolen this from my own previous webinar on Article 2, which is still available on our website. So just as a reminder of the structure, the right to life is obviously the right to life, as we know, is protected by law. That includes substantive duties, which are not to take life. Oh, excuse me. Sorry. So that means obligation not to take life, the negative obligation, and two aspects to the positive obligation, the systemic and the operational. The systemic is having in place a regulatory framework. The operational, of course, is in relation to a particular individual to protect that individual from an identified risk. And I should say, the slides for this will go up on Chamber's website with the video, so you don't necessarily need to take careful notes if you don't want to. Where there is a potential breach of any of these, and potential breach is my slightly loose terminology, but it's what we take from Middleton, there is then, that engages the procedural obligation, which is to investigate possible breaches of these. The positive obligation, as I say, has the regulatory systemic aspect, and secondly, the operational aspect. The systemic duty is to have in place criminal law provisions, legislative and administrative steps, and that can include taking reasonable measures to secure the safety of individuals in public places. The operational duty, key case on this is still Raybone. The most important questions are whether there's a real risk, which is a substantial or significant risk, and whether that risk is immediate, so whether it's present and continuing. Van Cole says it's a very high threshold. I'm not actually convinced that that really is true in all cases, but it's also true to say that not all cases where there's a real risk engage Article 2. And that, of course, is the issue that arose in Maguire. Because we know from Raybone that in the case of someone who is either detained under the Mental Health Act or is at least at risk of being detained because they're an informal patient, the obligation, the operational duty is potentially engaged subject to these factors here. What we didn't know was whether or not that would apply to those who were otherwise vulnerable, because Raybone refers to vulnerability as one of the significant factors in considering whether or not the operational duty might apply. So we come to Maguire. We've been joined by a dog. That's fantastic. It's okay. No, I'm always pleased to see people's dogs joining us. So we come to Maguire. Mrs. Maguire she was a lady with Down syndrome. She lived in a care home and was subject to a DOLS, as is very common. She was ill for approximately 2 days. She was seen by paramedics and GP on one day. She wouldn't cooperate with transfer to hospital, and the plan was for her to be monitored overnight and then to admit her the following morning if she deteriorated. She did deteriorate, she was admitted, and then she died the following day, actually the day after she was admitted, so there's 3 days here. The issues and concerns raised by the families were failures in communication between the different professionals, the lack of an advanced plan in place for getting her to hospital. And there were a few others, but they were the fundamental ones as relates to Article 2. The arguments, the appellant argued, the family argued that given her vulnerability, her lack of capacity, and the fact that she was detained, pursuant to the Deprivation of Liberty Safeguards Standard Authorisation. Article 2 was engaged, and that was just by extension of applying Raybone. They also argued that systemic duty was engaged, as in Parkinson, which is a case that is just over a year ago, I think now, but I haven't gone into it today because it's very long, and I'm sure everyone's already familiar with it. Respondent said that the detention was not connected to the risk of death, unlike in a psychiatric case. This is an ordinary medical case, which is the phrase that comes from Lopes to Sousa, and there was no systemic failure. So the Court of Appeal looked at a huge range of ECHR and domestic authority, and I've just highlighted some of it here. Most important case being Lopes de Sousa, which I think is 2018, I haven't put it here, where the ECHR gave probably the clearest explanation I've seen yet of when Article 2 is engaged in medical cases. And what they said was, in medical cases, only engaged in exceptional circumstances where life is knowingly put in danger, and that has to go beyond a mere error or medical negligence. So that has to be some sort of gross negligence type case, and where there is systemic or structural dysfunction. But importantly, and I think this is partly what the divisional court missed in this case, Lopes de Sousa said that there were different considerations in other contexts, including deprivations of liberty or vulnerable persons. So that's really, we can see why the family argued in this case that Lopes de Sousa doesn't really apply to someone who is as vulnerable as the deceased was here. So the Court of Appeal discussed these issues, and they looked at another two ECHR cases which are quite interesting. Nencheba was a case about a residential care home, so similar to this, but in this case 15 disabled children had died. The conditions were appalling, and the authorities were aware of those conditions and of an increased mortality rate. So that is outside of what we would think of as an ordinary medical negligence type case, where there's been a misdiagnosis or a delay in the ambulance arriving or something along those lines. That's clearly outside of that. Then there's Campano. I don't know how to pronounce that. Hopefully someone might tell me otherwise. In that case, the facility in which the deceased was kept had no heating, no food, shortage of medical staff and resources. So essentially the conditions again were awful, and the authorities knew about it. So that takes that imputability to a level above what you would normally see in a case where there's an ordinary error by a medical professional or a care professional. They also looked at, what they concluded was that in the ECHR cases where Article 2 was engaged, the substantive duty was to protect from a type of harm that was entirely within the control of those who cared for them. And we'll see a bit more about what that means in a moment. They looked again at Tyrrell, which is the death in custody case, which confirmed Article 2 is not engaged in a natural causes death in custody. They then looked at Dumpe, which is an ECHR case. Again, it was another deceased who had Down syndrome, was vulnerable and deprived of their liberty. In that case, Article 2 was not engaged, and the court felt that indicated that the operational duty would not be owed to those who were, even if you were vulnerable or deprived of your liberty, if you're seeking ordinary medical treatment, still doesn't engage Article 2 in the operational sense. So what does engage Article 2? Well, I've put 100 there. It's around about paragraph 100 to 102. What the Court of Appeal said was that there is a difference between an ordinary medical case on one hand, and on the other hand, a Raybone type case where a psychiatric patient is detained specifically to guard against the risk of suicide. In this case, the deceased was accommodated not specifically in order to protect her from a risk, but because she was unable to look after herself. She wasn't there for medical treatment. if she needed medical treatment, it was sought in the usual way from the NHS. So in terms of her relationship with the medical professionals, it was the same as yours and mine, i.e. She went to hospital like everybody else. Now, of course, the difficulty with that is that that's not, the practical reality is that that isn't actually completely true, because many people in this condition are dependent on those caring for them because they lack capacity, mental capacity, and they may also lack physical capacity to get to hospital. So they're not quite the same as anybody who doesn't lack capacity in terms of how they access hospitals. But, so I think the more important point is the purpose of the detention and its relationship to the risk that's said to engage Article 2. Because in Raybone, of course, the whole purpose of the detention, well, she wasn't detained, but the whole purpose of the possible detention was to protect her from the risk of suicide. They also considered the systemic issue and whether that was engaged, and they noted that in Lopes, they said that the life had to knowingly be put in danger by denial of access to life-saving treatment. This case didn't even come close. I think that's actually sort of obvious by reading the facts. Collective judgment on the 21st was to be kept under observation at the home, even though it was preferable that she would go to hospital. We know from Lopes that for denial of treatment to be an issue, it has to be really egregious. They then considered whether the structural obligation was engaged. They quoted this section from Lopes, and I think quite importantly, they said that the making of plans in individual cases, so the decisions made, don't engage Article 2, but also importantly, the detail of guidance given to paramedics is far removed from what the ECHR describes, which I think is interesting because there are lots of cases where it's argued that the content of some policy or guidance, in this case as it related to incapacitous patients and their admission to hospital, that the content of that guidance might engage the structural duties under Article 2 because it is part of the structure in which they operate. Now, this suggests that that is perhaps wrong because it says that the detail of the guidance given to them is far removed from what the ECHR describes. Now, clearly, if there were no policy on some very important issue, then that might well engage that aspect of Article 2. Or if the structures of the ambulance service were such that a call simply wasn't responded to, then perhaps that might. But in cases where there is something in place and it simply hasn't operated well on this occasion, which is what we see here, dysfunctional in terms of going wrong or functioning badly, this seems to suggest to me that that's less likely to engage Article 2, although of course everything turns on its facts. So the important points from Maguire, it seems to me, are that for the operational duty to be engaged, vulnerability isn't enough on its own. Being in state detention isn't enough on its own. We've seen that from prisons and now from this case dealing with dolls. Seeking ordinary medical treatment is unlikely to be enough. And I think the important point of all this is that there is, as I said before, a link between the detention and the cause of death, as there was in Raybone. What that leaves open is perhaps a question about detention in hospital. So what about someone who is under a DOLS but in a medical hospital for ordinary medical treatment, and then they die from the condition for which they were detained to be treated? There is clearly a link then between the detention and the event that caused the death. So I think in those circumstances, it would be arguable that the operational duty would be engaged because it's not, that could take the case outside of an ordinary medical treatment case. And the other question, which I haven't put there, is what about detention in a nursing home? Because the treatment in a nursing home is somewhat different. And if someone is detained and their treatment in a nursing home includes perhaps treatment for diabetes and the death relates to that, why would that not engage Article 2, given that there would be a link between the detention and the death? Questions rather than answers then in that regard. As far as the systemic obligation goes, it really just confirms what we already know from Sousa, and as I said a moment ago, the detail of guidelines being inadequate is not likely to be enough to engage Article 2. So the next case is Smith, 2020. This is a case that deals with the content or otherwise of conclusions in an Article 2 case, and was a little bit surprising at the time because it changes our perception of what we think should go in conclusions. I'll just skip quite briefly through this background. It's just a little bit of a refresher on what it says in Middleton about conclusions. It suggests that normally a narrative would be required because it has to bring the jury's conclusion on the disputed factual issues into the conclusion. And they said in Middleton that unlawful killing was inadequate in Armin, that it would be helpful to consider what defects contributed to the death and other factors which are relevant. Middleton said, as everybody is very familiar with, that the conclusion could be judgmental. This is one of the most significant aspects, of course, of an Article 2 being engaged. And that then from that, we have the Chief Coroner's Guidance 17, which says that permitted judgmental words include inadequate, inappropriate, etc. Now, interestingly, none of those words actually appear in Middleton. They're words that I've seen in conclusions on many occasions, and the general assumption based on the Chief Coroner's Guidance seems to be that they're entirely appropriate. But Smith is the case which questioned that, and we'll see that why in a second. Tainton, another case that everybody will probably be very familiar with, where the High Court, I think, found that where there were admitted failings in an Article 2 case, even where they didn't contribute to the death, those ought to be included in the conclusion. So far, so straightforward. But Smith was a suicide case of someone who was living in the community under the care of the home treatment team. The expert was highly critical of the home treatment team and the medical cover. The coroner was also critical of them in her findings, but she was not persuaded as to causation. It's always difficult in suicide cases to come to conclusions as to causation. But the family argued that even absent the issue of causation, that the critical findings of fact ought to have been in the conclusion, relying partly on Tainton. And I think it's important, I'm not going to read all this to you, but you can have a look at this later, that the court invited the family to propose what they said the coroner ought to have included in the conclusion. And they included this, and it's fairly critical, but I wouldn't say it's far removed from the sorts of conclusions I'm used to seeing in these kinds of cases up and down the country. But what the High Court said was, we cannot approve of language of this sort for either Part 3 or Part 4, Box 3 or Box 4, as I would usually call it, of the record. They referred to Middleton, and they reminded everybody that the prohibition in Rule 36(2), which is against conclusions as to matters other than the 4 questions, must continue to be respected. And they reminded us that what Middleton envisages is conclusions of fact, not expressions of opinion. And they said it was neither necessary nor convenient for the failings to be added. It would be wrong. So this seems to go directly against, first of all, the Chief Coroner's Guidance, and secondly, Tainton. And they referred to Tainton and said that the argument that the failings should be included is an argument of form over substance. I think what they really meant there was that if the failings are admitted or found by the coroner, then the question of whether they go in a particular box on a form is form over substance. I think many families would disagree with that, but that's, I think, what they're pointing out. So first of all, looking at non-causative failings, well, Tainton, in fact, said, the often forgotten bit, is that such a statement, which in relation to the admitted failings, would have completed the incomplete account of the circumstances in which Mr. O'Neill met his death. And in Smith, they said it would be wrong and an argument of form over substance. So it seems that in Smith, they didn't consider it was necessary in order for the conclusion to completely account for the circumstances, whereas in Tainton it was necessary. So the way to square the two, it seems to me, is to ask whether non-causative failings need to be included in order to completely account for the circumstances. But it seems that there's at least debate, because these are both High Court decisions, as to whether or not there's an obligation to include them. And in terms of language, Middleton does say a judgmental conclusion, so that must mean something. But we have to remember that the 4 questions include, and in an Article 2 case, including in what circumstances, are limited. This 2020 Smith case says the conclusion should be a fact, not expressions of opinion. So how do we square that circle and deal with all of that in a conclusion? Well, in Middleton, helpfully, the House of Lords, as it then was, actually proposed a conclusion which they said would have been adequate. And what the conclusion was this: the deceased took his own life, partly because the risk of doing so was not recognised and appropriate precautions were not taken. This embodies a judgmental conclusion of a factual nature. So I think really it's all a question of balance and appropriate language, because that is critical, but it is measured. And what it doesn't do is use words like inadequate, inappropriate, insufficient, lacking, unsuitable, unsatisfactory, which seems to me go a little bit further. And I would suggest that if Smith turns out to be right, and it may be that there's some further case that continues Tainton and Smith, that the Chief Coroner's guidance perhaps goes a little too far. But of course, it is only guidance, it isn't law. But it's a useful case, particularly if you want to limit the range of what a coroner has in their conclusions. The other thing that Smith addressed was the issue of causation. Very helpfully set out what we already know really, but it's useful to have it set out, particularly so recently, that the standard of proof is balanced probabilities and the threshold is essentially material contribution. So for those of us that are PI lawyers, it's quite easy to apply because we're used to doing that anyway. Family argued that the expert had given the coroner statistical evidence which showed that the deceased wouldn't have died had she been admitted. But the High Court were critical of that and said, well, you can't really draw such conclusions from statistics because all they really say is fewer than 50% of people will die in X circumstance, and that doesn't really tell us very much. Again, obviously that very much turned on the fact, but it's a useful argument, which I've actually used in a case slightly before this in terms of using statistics to reach conclusions which aren't really supported by them, which sometimes people can be quite keen to try to do. So we've got to the end of the inquest, and we now want to either recover the costs or avoid paying the costs, depending on which side we are on. Fullock is a case from 2019, which refers back to Roach, which everybody will be very familiar with anyway, and it gives some helpful consideration to the kinds of issues that we should be thinking about in terms of costs. This is a death in custody case. Excuse me a second. And fundamentally, it all went away shortly after the inquest, as is not uncommon in this kind of case. The inquest was attended by counsel and a solicitor. There were 2 PIRs, which were also attended by counsel and solicitor. Settled for a modest sum and a cost bill of $122,000, which actually doesn't really seem that surprising, given that there was an inquest of, I think, a week or so, and 2 PIRs, and obviously lots of other work. What the Deputy Master found was that the PIRs were instrumental. They enabled the claimant to get their own pathology evidence heard at the inquest, and they managed to get certain witnesses to attend. And that the inquest went further than evidence gathering, which is obviously the starting point for you getting your costs under Roach, but that the settlement was reached without civil proceedings. So there's that secondary issue, which is, first of all, gathering information, but also resolving factual issues. Because although we know that the findings of a jury or coroner aren't binding, where there's disputed facts, like in a case like a death in custody, it's likely to be pretty persuasive when you come to negotiate later on. And the Deputy Master also said it was artificial to suggest that the work done and the preparation is somehow not part of the civil claim. On appeal, Mr. Justice Slade noted that the authorities emphasised the need to identify the issues and their relevance to the other proceedings. And then once that's been done, we have to consider whether it's proportionate to the matters in the civil proceedings. And he went on to do that and to say that the conclusion of the inquest dealt with issues which were relevant to civil proceedings, including policies, procedures and training. So there's clearly a direct link between the inquest and the civil claim. PIRs that deal with agreed matters, unlikely to be proportionate or reasonable for a proceeding party to attend. Although one might wonder sometimes whether the coroner actually is directing you to attend. Those coroners that are keen on doing full directions after every hearing that are written will often direct that everybody attends, in which case that might be a counter to that argument. Specifically, the first PIR, Mr. Justice Slade said that it would be correct to say that the family would have been remiss in pursuing the claim not to be there. And as far as the second was concerned, it dealt with important issues about getting questions to the expert. So both were relevant. And as to proportionality, it wasn't a high value case, but of course it wasn't just about money. Looked at Roach and said that the inquests in some cases, in practice, have the effect of causing proceedings in the civil proceedings later to be relatively speedily compromised. And I think we've all seen that in practice, that sometimes the issues between the parties are actually resolved by going through that inquest process. And obviously, if that's right, then what you've really done at the inquest is your whole litigation, the whole of your clin-neg claim, if it's a clin-neg claim, which would have costs of hundreds of thousands, may be dealt with much more succinctly. So actually, it may be in a much more proportionate way to deal with matters. The next question is the value of the assistance gained should be weighed against the cost of pursuing that particular point in the inquest, and that's obviously very particular to the individual circumstances. And we should stand back and consider the total cost of participation and its utility and relevance to the outstanding issues in the civil claim. So looking at the other way, in a medical case where really the facts aren't particularly disputed and it's all going to turn on expert evidence on breach of duty, if the coroner's not considering that because they don't have an expert and they're not looking at breach of duty, then it might not be proportionate to be involved in the inquest. One has to look at what issues are actually going to be resolved by the inquest and whether they're issues that are going to arise in the civil claim. So finally, I'm going to have a look at the guidance that's been issued in relation to COVID-19. There's, I think, 4 different sets of guidance, one of which has subsequently been amended. And I'm not going to go through it in a huge amount of detail because it's all out there for you to read. But just as an introduction to it, in terms of hearings, the first guidance at the very beginning made clear that a coroner has to be in court for an inquest to proceed, unlike lots of other types of hearing, and unlike we've seen the Supreme Court sitting in the judges' houses, which has been very interesting to see where they live. I've done various hearings on Teams, and we've seen judges' houses and judges in what seem to be other places. That can't happen in inquests, and only urgent matters were proceeding. More recently, there was some guidance on remote participation. Again, reminded that the coroner must be present. Parties and others can theoretically be remote if the facilities are there, although of course we know that the nature of facilities varies wildly depending on the coroner and the local authority. Courts can and should be used if they can be socially distanced. I had a very good experience of this at Leeds recently. I did a trial in Leeds County Court where they did a fantastic job of marking out the court, blocking off lots of seats so you couldn't sit on them. Everybody had their own space with your name on it where you were allowed to sit, and everybody was socially distanced. There were masks, there were gloves for the witnesses to handle the witness bundle. It was fantastic. Whether we'll see that in coroner's courts, I haven't seen any of it yet. Are we seeing remote hearings? I certainly haven't seen any. I'd be interested to see if anybody wants to tell us that they have seen it. I am told, or I've seen online, that the coroner in Brighton and Hove has been doing remote hearings, but certainly most of the coroners in the Northwest, as far as I'm aware, are just not sitting at all at the moment, although I'm sure that's going to change soon. The most controversial guidance was that in relation to the workplace and COVID, and of course we've seen through the progress of the pandemic that there were issues about PPE, and lots of people were interested to know what coroners would do in cases where, for example, care workers, nurses, doctors had contracted COVID and had subsequently died, if there was an issue about PPE. Now, the first set of this guidance seemed to quite firmly indicate to coroners that they ought not to be looking into those issues, or at least that's how I interpreted it, and that's, I think, how many others interpreted it, and quite firmly suggested that they ought to be waiting for a public inquiry. Of course, the problem with that is, at this moment, there is no public inquiry and none has been announced. So my view is, if there's a case where it arises, then the coroner is obliged to consider it, and consider whether Article 2 is engaged, and can't simply say, well, there might be a public inquiry, so I'm just not going to look at it. What the amended guidance makes a bit more clear is that it's up to the individual coroner. An inquest may be required, although COVID is a natural disease and it's capable of being a natural causes death, it's also notifiable. And where there's reason to suspect some human failure, an investigation and inquest may be required. And it's obviously a matter of judgment for the individual coroner. Interestingly, what it then does is refer to Smith, which is a case where they were considering MOD level policy in terms of equipment. And Lord Phillips observed that whilst an inquest could consider whether a soldier had died because a flak jacket had been pierced by a bullet, so the adequacy of that jacket, the inquest would not be a satisfactory tribunal for investigating whether more effective flak jackets could and should have been supplied. So this is clearly trying to presage the argument that will be made by trusts or the NHS or whoever maybe the coroners try to bring in as parties, that inquests aren't really the appropriate place to be looking at matters of national policy. So what does that mean? Well, clearly coroners can consider these issues, and I think if it's clear that it is an issue, I don't see any reason why a coroner would be able to avoid considering it. If someone has contracted COVID and died, and they did not have PPE, and they worked in a place where they probably ought to have had PPE, it's an issue and it's clearly relevant to the death, and I don't see how a coroner can avoid investigating it. It would clearly, in my view, engage Article 2, because this is a systemic obligation would be to have in place a system to protect life. Whether or not that was breached would depend on exactly the circumstances and how it came about. Smith doesn't actually prevent considering the issue as it relates to the individual death. It doesn't prevent a coroner from finding that this person did not have access to adequate PPE and they contracted COVID. What it might do is limit the scope if we start getting into issues about why PPE wasn't available and whether it's because of sufficient national resources or national advanced planning. Smith may limit that, but I don't think it would really prevent looking into issues at a local level if it's about distribution or availability, for example, for GPs. I know lots of GPs had difficulty getting hold of PPE. I said I wasn't going to cover absolutely everything. So there are some other cases. Morgan is the big one. Obviously, I haven't covered. The reason I haven't covered it is because it's been appealed to the Supreme Court. As we know, what it says is the standard is balance of probabilities for suicide. That remains the case for now. Beyond reasonable doubt for unlawful killing, for the simple reason that one is a crime and one isn't. I'm massively oversimplifying, but that's fundamentally what they said. Supreme Court heard it in February 2020. When will we get the judgment? Well, I've had a look at the sort of timescales, and they could be anything between 6 and 12 months from the hearing. So we simply don't know, and I'm not going to try and predict what they will do, because I don't think it's possible. But I'll say I wasn't too surprised by the Court of Appeal decision. That's all I'll say. Lee is a case looked at application of Rayburn in the community. I was going to include it, and then I read the judgment and I found it extremely difficult to understand. So if you're particularly interested, have a look at it. But what it really says is, maybe Rayburn could apply in the community, it depends on the circumstances. My view is, I don't see any reason why it can't, because in Rayburn, the deceased was not detained. Article 2 was engaged because she could have been detained. They might have detained her if she tried to leave. Now that would apply equally to someone under a home treatment team, for example. If they're actively being treated by a psychiatrist, then they are always susceptible to being detained. So the logic, I think, can apply equally, depending on the exact nature of the relationship and the treatment. Dyer is a case that looks at the reasonableness of using screens and talks about the importance of families being able to see those giving evidence. And then two final points: Birmingham bombings inquests. The Chief Coroner who's sitting there, the coroner who's sitting there, gave some guidance on how to consider applications for anonymity. And in the deep cut inquests, there was some guidance given on how to consider evidence, whether to admit evidence of propensity or bad character. And in that case, the coroner adopted the provisions of the Crime and Justice Act 2003, which I had to refresh my memory of because I haven't done crime for 10 years. But that's the bad character provisions, which I'm sure you'll remember studying at some point in the distant past. They're obviously the criminal bad character provisions. I'm not necessarily convinced that it's appropriate to apply those, certainly not strictly in inquests, because quite properly, inquests have a more relaxed approach to evidence because they are inquisitorial and because they are fact-finding. But anyway, that isn't an authority that says that Section 100 applies. It's just an example of the coroner applying it. So those are all the questions to look at. I've had to see there's a few comments in the chat, so I'll just have a look and see what they are. And then I will see if I can answer them. Interesting. Thanks, Adam. Apparently remote hearings are taking place in Birmingham. I presume that's Mrs. Hunt, is it, that's having remote hearings? She's the coroner. I've been in front of her a few times. She's very organised. I'm not surprised to hear that she's one of the people that's doing that. Someone else, Laura, says we had our first remote hearing last week, and another listed for today. Someone else has had a remote PIRH in Sefton. Well, this is good that there is some movement and things are actually being progressed. Have anyone who's had them, what are the coroners using? Are they using Teams, or are they using Teams? Okay, which is not my favourite. I think Zoom is a little bit better, but I know why everyone prefers to use Teams. I think there's some security concerns about Zoom. So before I finish up, does anybody have any questions? You can either unmute yourself and ask if you want to, or you can pop them in the chat. And a tip that I always give that I discovered a while ago, which is great on Zoom, if you're muted and you want to unmute yourself, just press the space bar and you will be temporarily unmuted, and then when you release it, you are muted again. So it's fantastic for meetings if you've got lots of people in. But if anyone's got a question, pop it in the chat. I'll give you a minute to do that. If you want to ask me something directly, always welcome to drop me an email and I can have a bit more of a think about it and I can answer it later. I thought someone was asking a question, but maybe not. Well, that's all I wanted to do for today. If you want to ask me a question, say drop me an email. Otherwise, hang around. I'll hang around for a minute in case anyone does have a question. But otherwise, thanks very much.